Good morning. Good morning, everyone. I hope you all are doing well this morning. Before we begin the session, I would like to acknowledge that Legal Aid Head Office is situated on the unceded territories of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. I would also like to acknowledge that many of you are joining today from many places near and far and acknowledge the traditional owners and caretakers of all those lands. So it's my pleasure to introduce our wonderful speaker today, Callie Melnick. Callie Melnick is a supervising lawyer with the Thompsons Rivers University Community Legal Clinic. Callie was called to the bar in British Columbia in 2017. She has been with TRU Community Legal Clinic for a year now, and prior to this position, Callie worked in private practice. Callie practiced in advanced planning issues relating to elder law, residential tenancy, family and criminal law. Callie is a passionate speaker, and she has a passion about access to justice and assisting low-income clients who would otherwise not be able to access legal services. So along with me, please welcome Callie. Thanks, Callie, for joining us today.
Thanks, Baljinder. I feel like my ego just grew huge there. I want to thank Baljinder for the opportunity. And at this time, I'll just also recognize that I am speaking from the Thompson Rivers University Community Legal Clinic, which is situated on the traditional and unceded territory of the Tecumseh to Secwepemc people. I want to thank everybody for always thinking of us during these times. And I know the band here has been through a lot, and so we really appreciate the thoughts out here. So today we're going to be talking about residential tenancy matters and the impact of COVID-19 and some legislative changes that I think found their way pushed through a little bit quicker as a result of COVID-19. And so it's kind of a good thing. Some of it's, been a little bit weird to adjust to. I'm not going to be focusing as much on unpaid rent as I would have, say, in the fall, just because the time period that was put forward would be to July 10th for those the unaffected rent. But I'll speak a little bit about that later on. So for those of you who don't know about the TRU CLC, because the full name is a bit of a mouthful. We're located in downtown Kamloops, and right now all of our services are being essentially run over phone and by Zoom, with signing appointments being done in person. But otherwise, a lot of our students are still working remotely, and so they're kind of scattered across the country right now. We are the first student staff-free legal clinic in the interior for BC. And so our students are for credit, but they work under the guidance of myself and our executive director, Ted Murray, who is also a lawyer. And we kind of split our practice areas between the two of us, and I'm responsible for all residential tenancy files. So again, it's for lower income clients. And so the students get the practical experience, but also they have the ability to work with clients and learn about access to justice within our legal system, how they can play a role in that. And hopefully we're going to make them better lawyers. In my opinion, hopefully less worried about profit and more about helping people, which most of them are. I don't want to make too many jokes about lawyers, but the more lawyers working in access to justice areas, the better, in my opinion. So we do a low income financial threshold assessment. And so if our clients can meet that threshold, then we'll be able to potentially give them full representation. At the very least, we try to give it summary advice to all clients if we can, depending on the nature and scope of their issue. So the intake interviews are run entirely by the students, at which point, once they've collected enough information, the students check in with us, and then the supervising lawyer will guide them through and determine what kind of scope of service we can offer. So, and full representation, so for litigation files, we'll do residential tenancy, human rights, employment standards, small claims, and some criminal charges, although that's been a little bit up in the air as a result of COVID because the courts required by Zoom. And so it was just kind of difficult to have students who are not in the province or even in the city attending virtual hearings with clients when they're not in the same room and as a supervising lawyer. So it just became a little bit difficult. So that one's a little bit on hold, but we're hoping come the fall we'll be able to get that back up and running. We do some full representation and limited assistance in drafting documents. So we will draft wills, representation agreements, powers of attorney. And sometimes in advanced draft, we haven't really had them come through. We'll do notices of claim, replies to claim, and small claims. And then we also do a lesser known service that we are trying to really push is we will help draft financial statements for clients in provincial and small claims. And so that's a very limited scope of service. And then we also assist with uncontested desk order divorces. We will provide summary advice or limited summary advice, summary information for family law litigation. So we don't represent clients in family law disputes, but we will give them some advice, probate or estate, most matters within jurisdiction of a superior level court. So we're not really hopping up into Supreme Court very often. And that's largely because our students are not temporary articled. And so they can't appear in front of a superior court justice, especially if they don't have their articles. Well, essentially because they don't have their articles. And then we get a little bit of business and commercial real estate and personal injury claims that will come in, but typically those ones we will do maybe some summary advice, but usually it's an immediate close because there's money involved that means that the client can usually afford a lawyer, usually. We don't do impaired driving or traffic offenses or unionized employment. And then we obviously, we don't want to take on complaints against doctors, lawyers, dentists, those types of professional organizations, just because the complexity required for them. So let's get to the meat and potatoes of today. So residential tenancy matters. The most common issues we deal with, and if you're a legal advocate, you're going to likely be dealing with, are evictions. And so we see 10-day notices for the non-payment of rent, and those fall under Section 46 of the Residential Tenancy Act. So if I'm referring to a section number, it's going to be out of the Residential Tenancy Act, the current one, unless I otherwise say it's a different piece of legislation. So you can just safely assume I'm talking about the Residential Tenancy Act. So 10-day notices are typically for non-payment of rent or utilities. That one's a little less common, that it would be a utilities point for eviction. But the non-payment of rent is definitely the most common for the issuance of a 10-day notice. The next type would be a 1-month notice to end tenancy for cause, essentially. This tenant is continually breaching quiet enjoyment or is being a nuisance generally, has the property in a state of disrepair and is not complying with requests I shouldn't use disrepair, in a state of that's making it unsafe. So, for example, we've dealt with a couple of files recently where the tenant is an alleged hoarder, and so the safety and health and safety of the unit is in question, and so that would be a purpose for a 1-month notice. So those fall under Section 47. And then we have 2-month notices to end tenancy under Section 49. So that's if the house is going to be used for a family member of the landlord or the landlord themselves, or if they're selling the rental property and the new buyers do not want tenants in there, a 2-month notice would be issued in that regard. So those fall under Section 49. And then also under Section 49, sub 6, we have 4-month notices to end tenancy. And so those are the very commonly referred to rent evictions. And I'm going to talk a bit more in detail about rent evictions just because we have a bit of a change coming, I shouldn't say coming, it's come into effect on July 1st, 2021. And so I'll deal with how those are now assessed and and essentially granted by the RTB before an eviction notice can be issued. But so those are under section 49 sub 6. Now, if we have a monetary order as a result of an eviction or say a notice to end tenancy given by the tenant, we might have to pursue a monetary order for failing to return the damage deposit. So that's under section 38. Those are very common. Or disputes over whether the damage deposit should even be returned. It's not uncommon for landlords to just not return the damage deposit because they don't think they have to for whatever reason, and that's not really given to the tenant. So those are one type of monetary order we often work on when it's related to an eviction. And then under section 51 of the RTA, a tenant can seek compensation if the landlord has failed to take the steps to comply with that reason for eviction under section 49. So the landlord says, oh, my son's moving in. You got to move out. And then the son never moves in. And then all of a sudden there's a for sale sign up, 3 months after you've moved out. Well, now all of a sudden we have cause to pursue compensation for that because they didn't comply with the son moving in. So if you have a client coming to you with an eviction notice that says so-and-so is moving in, or the landlord wants to use it for their own purposes, like for their own use moving forward, they want to move in, and you're able to determine, because especially in smaller communities, it's not difficult to tell if your landlord's living at the property or not, or their family members. It's probably a little bit more difficult in more urban centers, but if it looks like the landlord's not complying with the stated purpose, then you can seek compensation. They can be a little bit tricky because it really does become who's more believable. And it's prior to the change to the 4-month notice, that was very common for evictions, where the landlord has said, oh, I have to do major repairs. You need to move out. Doesn't provide any permits or anything like that to establish that the renovations are actually occurring. Tenant happens to drive by and it's like, they didn't do anything. And now somebody else is living there. That can be tricky because really it just the landlord will end up having just to demonstrate to the arbitrator in a hearing, well, I actually did have to do some renovations, but then, I've had a file where the renovations weren't as extensive as we had originally thought. And so we're pretty lucky we were able to get it done, faster. And we only had to disrupt services for, 5 days instead of 12 that we thought. And so what becomes reasonable to the arbitrator is changing because the landlords made it look like, oh, we did do it in good faith. And it just happened to be that we were lucky that we didn't need to do all of these things. And so they can be tricky that way, but I digress. So the other issues that we deal with is compliance with the Residential Tenancy Act. And I kind of want to preface this in that a lot of times we find ourselves being used as the dispute resolution for a personal conflict rather than what can be a legal conflict. And this can arise in a couple of ways, in that maybe the client is a person with disability, and so they're at home more, or they have a mental health a disability. And so it can get tricky in that sometimes somebody might be more sensory sensitive to sounds, lights, things like that. And the COVID has really amplified those sensitivities. And so it's not so much that things have gotten worse, it's just they're feeling it more. And we can't legally help with that part of it. And so we're really lucky in that for a lot of these types of issues, the neighbor disputes and quiet enjoyment in particular, we have a social worker on staff who is our outreach worker. And so oftentimes it's a matter of asking Samantha to have a conversation and try and dig down a little bit deeper to see if there's something non-legal that we can help with in these types of complaints. So neighbor disputes, we do try to help if there's a legal element to it. So for example, if a neighbor's not following the building rules, noise, so that kind of falls into that quiet enjoyment, not keeping common areas tidy, especially during COVID, there was we had a lot of calls about this person's, not wearing their mask, or this person's touching all these things, and they're having people over when they're not supposed to. That's against COVID protocols. They're having people over to their apartment all the time, and I don't like that. It's not so much a matter that we necessarily can really deal with, other than saying, if it's a COVID breach, COVID order breach, that's something that ends up having to be reported to bylaw or the Interior Health Unit that was assisting with that. So we haven't clearly gotten a lot of those calls in the last few months because things have loosened. So that seems to have calmed down a fair bit. But another one is they leave the door unlocked. One of the common doors to the building, they'll leave that unlocked. And so sometimes we can help with that if there's that legal element to it. And if it's getting into a bit of, there's building rules, everybody's agreed to these things, reaching out to the property manager or the landlord to say, hey, you got to enforce it equally, and we've got this type of evidence to suggest that this is happening. So that's under neighbor disputes. That one's a little tricky because, like I said, it can very much so be more of a personality thing. And so one of the things we tell people when we're providing advice on neighbor disputes is if it is something where your landlord's not following the rules or breaching certain building policies, that you should always deal with your landlord or property manager in writing first. Call. If you can't do text or a letter or email to your landlord or property manager, then you can call. But what we want to make sure of is that somehow your landlord or property manager is being told that there's this problem, you've documented it, and that you would like them to deal with it. And then after that's been raised with your landlord, they should be coming back to you, or your property manager coming back to you saying, I approached X neighbor. These are the steps. I found that your complaint is valid or not valid, and whatever the case may be. And what are the steps taken to resolve the problem? And if it continues, then continue to follow up with your landlord again and make sure that they're aware that the problem is persisting. And if they refuse to fix the problem, you've got that written paper trail for dispute resolution with the Residential Tenancy Branch if it's something that needs to be enforced. So that typically is where we fall under quiet enjoyment, which is Section 28. We always want to have that paper trail to make sure that we've got evidence. So if the landlord isn't taking steps to remedy the situation, or they're saying that's between you and the neighbor, I don't want to get involved, you've got that little bit of paper trail to take to the RTB when and if you have to file an application for dispute resolution. So every person is the quiet enjoyment piece for people who maybe aren't necessarily aware of what exactly that means. Quiet enjoyment is it's a part of any tenancy agreement in which tenants have the right to peace and quiet and privacy in their home. And so it has to be treated as such. And so this includes being free from unreasonable disturbance. There's a certain level of permissible disturbance especially when you're living in, say, an apartment or duplexes, townhouses, things like that with shared walls, right? If you have a shared space or shared walls with people, there's going to be some sound transfer. And so the Residential Tenancy Branch has their own policy guidelines on what would be permissible, where's the line in that regard. Walking, playing, kids, we get a lot of, especially during COVID, during the peak of it, my neighbors are so noisy. Now that you're working from home, you're hearing it, right? Your neighbors' kids are running around at all hours. Well, really, they're just running around now a little bit more during the day, and now you're home and you're hearing it, or their hours are a little bit scattered, so maybe the kids are staying up later than they normally would have pre-COVID, right? So it's just, it's kind of an interesting scenario in which you have to kind of determine as the advocate, well, is this really unreasonable, or is this, shared walls, shared floors, ceilings? It's going to be a judgment call. And also, what kind of evidence can you bring? Because really, at the end of the day, that is what's going to matter if you're bringing a complaint through the application for dispute resolution with the RTB, is what can you really prove? If you're going to say the neighbor upstairs is walking like they've got concrete shoes on, and I've asked them, can you try and stop, or at least, not be walking around at 2:00 in the morning, you kind of need to have something that you can take to the residential tenancy branch, or they blast loud music at 1 a.m, or they wake up at 4 for whatever reason at work, and when they're getting ready, they feel it necessary to have their music up loud. Are there other neighbors that hear that? I see that there's a lot of questions coming in, so maybe I'm just going to take a moment and go through some of them. Okay, so Michelle, I've got a client's been dealing with landlord's son constantly entering the unit. Okay. Okay, so I'm going to get to entry. So it sounds to me, Michelle, like the big thing is going to be having evidence of that son just kind of coming in, and what exactly is the separation between the upstairs and downstairs. I'll get into a little bit of entry, because that does technically fall under quiet enjoyment, but also if it's the landlord's son, is he acting as agent? There's some questions there. So that's an interesting scenario. You could still do an application for dispute resolution, but if they're almost done their lease and they don't want to stay, which is, usually the question, if you're almost done, can you put up with it for another month or two? Because right now, residential tenancy branch hearings for issues like that are usually booking out three or so months out. So depending on how much is left in their lease, it might be questionable as to how much you want to do. And each report to the incident, if you can get the police file and then have that as your evidence, that's a great a piece of evidence that the client's reported it each time. So yeah. Changes to the law in the works that would deal with the issue of extreme heat in certain apartments. I don't know if there's anything coming down the line, but it is it's an interesting question, because especially for Vancouver, from what I understand, that's going to be an interesting one. You know what? I think I'll get to that when I get down to repairs. Francis, just remind me when we get down to repairs to do that. I think, Patricia, that's a good question. I think that text messaging, you know what, if you can screenshot it, it can find its way into an evidence. It is a form of writing. And I think with respect to the residential tenancy branch, it is, we use screenshots all the time for evidence. Writing via email, they're all going to be about the same. It's some way of recorded conversation, right? And so if you are going to be saying to clients, if you text message and you bring us the responses, I'll talk a little bit about this as well in a little bit more, is that evidence from your client has to show sometimes both sides, even if it looks bad. So I'll talk a little bit about that evidence piece. I'm just going to make a little note here for myself. Evidence. Okay. I'll answer just a couple little more, and then I'll hop back into it. Okay, so geographical boundaries of our clinic. So we can, Patricia and Francis, we can take calls from all over the province. We've been doing that during COVID. Our usual practice pre-COVID was to have clients attend in person. And so that did quite restrict us to Kamloops and surrounding area. And the reason why we will take calls from outside of the province is when we outside the province, outside of the Kamloops and surrounding area, so Merritt, Clearwater, Ashcroft, Cache Creek, Barrier. We will take those calls and we will give summary advice, but then we're looking to refer out to other advocates, just because we don't want to be stepping on the toes of where the Law Foundation is providing funds. So we won't do full representation for clients in Kelowna because there's other service providers that we can then refer them to. And also geographically, it does make it very difficult because then the client's having to come here to do their stat deck and coming here to do the hearing. So it's better to have a person that is outside, or sorry, that is in that person, like the client's geographical area. Just service-wise, it just makes more sense. We were doing some satellite clinics pre-COVID, so we were going out to Salmon Arm and Merritt, and I think we were also out in Ashcroft for a little bit, where we would do like a day a month. We would rotate through, and I think Lillooet, but that was all put on hold. So maybe back in the fall, we'll be able to start that up. Okay. How best to proceed with the landlord who is violating quiet enjoyment? That's checking if tenant has a pet. Yeah, Don, that is a breach of quiet enjoyment. And peering in windows, that's a little bit voyeuristic, even if it is for a purpose of checking to see if there's a pet. And I mean, part of me says, well, that should definitely be reported to our CMP because that is a breach of privacy, really. And another part of it is also to be, and I feel for the low cost client, like the low income clients, because but the frustrating thing is, in my mind, I can understand the concern. Tenancy vacancy rates are so low and so tight, and rents just continue to increase. One thing you could do is if your client's not on the BC Housing Registry at this time, maybe start that process, because a lot of the housing registries in a lot of communities have huge wait lists. So that way, if something were to happen and they wanted to just move rather than deal with it, then at least there's a plan in place or plan in motion. Or the other group that we deal with quite a bit here in Kamloops is Ask Wellness, and they have a great housing worker. But just because a tenant, and this is so frustrating, just because a tenant can't afford to move, they shouldn't have to put up with that, in my opinion. And that's easy for me to say because I'm not that tenant and I don't live in that scenario. But as an advocate, making the client understand that they don't have to put up with that, and holding that landlord accountable through the Residential Tenancy Branch, because you can't evict someone based on revenge, based on a complaint like that. So if they have some kind of proof that the landlord is doing this, and they can demonstrate, especially, if there's a video of him peering through or her peering through the windows, or a witness saw it and is willing to come forward and confirm the allegations of the tenant. Yeah, I think that's really important that tenant is has that confirmation that they are able to deal with their with that issue in the right way. I would suggest that they make a complaint, in my opinion. Yes, I can get copies of the slides to Baljinder to supply out. That's not a problem at all. Yeah, so I'll do these last two and then I'll hop back into it because we're almost there. So with the renting a room and the landlord resides in the room, in the home, so they're roommates, the RTA won't apply. So if they're sharing a bathroom, if they're sharing a kitchen, if it's a shared space and you're just renting the room, then it would be the RTA would not be applicable. So they would be just roommates. So if there is any kind of compensation sought for damages or anything like that, then you would have to likely, depending on the amount, go through the civil resolution tribunal. So if it's under 5,000, that's where they would make a complaint to seek compensation for that. Yeah. When tenants, service for the evidence submission. Yeah, it does have to, you can do it by email if an email has been provided for service. So you have to look at the application for dispute resolution to see if an email was provided for service. Otherwise, it's typically by hand, posted to the door or in the mailbox, left with somebody that lives with that tenant, or by registered mail. So you do have to deal with that. Helen, I'm gonna deal with yours in a little bit. Okay, so I'm just gonna leave that one open for now, and just jump into a little bit of this. Okay, so we're at quiet enjoyment. So part of the quiet enjoyment, there is the obligation that the tenants have a right, but it's a mutual obligation as well. And so you have to make that clear to clients. So you're allowed to have guests over. You can have music playing at a reasonable level. You can practice your religion. You are free to live in your home. That being said, it is not uncommon for us to get clients, my neighbor's so noisy, they make all this ruckus, but I'm the one that's getting complaints complaint letters from my landlord. Yeah, but how have you been responding is usually my question for the students to ask, because more often than not, the issue is that the client has come to you to say that their neighbor is so noisy, but they have been yelling back at their neighbor and just disrupting people, that share walls with them. They've been banging on the roof. They've been going upstairs and banging on that door to tell them to be quiet. And they themselves now are breaching the quiet enjoyment of everybody else. So regardless of however that upstairs or downstairs or sideways neighbor has been behaving, your client has a duty to also then still respect the other neighbor's quiet enjoyment. You can't take it into your own hands and start yelling and calling the police at all hours because they're making noise. It's not going to help you in an eventual RTB claim. And we often find that it ends up being our clients that get a complaint against them that will eventually lead to 1 month notice to end tenancy for cause. And sometimes you have to say, yeah, because you've been warned for 4 months in a row to stop yelling at the other neighbors, stop calling the police. There's no substance to your complaint. And it's really frustrating on those files because you want to help the client, but at a certain point you can't. Okay, so repairs. Repairs are an interesting one under Section 32 and 33. Because what they do is there's landlord responsibilities and tenant responsibilities. So a landlord must provide a rental that meets the health, safety, and housing standards required by law, and it has to be suitable for occupation and in good repair. So for that to happen, the landlord has to also provide the tenant the contact information for who are they supposed to call if there's an emergency repair needed, and they're responsible. Their responsibilities are limited to repair damages that are not caused by the tenants or their pets, right? So if your pet has chewed baseboards, well, that's not going to be on the landlord to repair. That's not usual wear and tear. That's going to be up to you, the tenant, because you caused it, right? And so there's going to be a line that's going to get drawn in that regard. So for the tenant, that creates that obligation on the tenant to maintain a reasonable health and cleanliness standards throughout the unit and common areas. And so that's where that question of hoarding kind of starts to come in. Or if, sadly, there are clients that either have mental health disabilities or physical disabilities, or they're elderly, and things just kind of get away from them, right? And so when that happens, I'm not saying the landlord's right, because I don't usually, we only usually act for tenants, but I'm also, of the knowledge that sometimes the tenant has just gotten themselves in this situation, got out of control. So the tenant has to repair any damage that's caused by them or their pets. And if there is a repair, say the stove stopped working, then report that repair that's required to your landlord in writing, text, email, written, if you can. Definitely get that repair request into your landlord as soon as possible. And there's a reasonable amount of time in which the landlord has to do the repairs, unless it's an emergency, right? And so if it's an emergency, that's going to be a bit of a different situation. So if it's a normal wear and tear or emergency repair, the tenant's not responsible for making that repair. However, if it is an emergency repair and the tenants try to get in contact and, oh my gosh, that leak in the pipe under the sink that I've been telling my landlord, it's just now a overflowing bathroom. Yeah, call the plumber. And if you've given your landlord a chance, you've called that emergency repair number, nobody's getting it back to you. Call a plumber, get it in, keep the receipt, and then seek reimbursement from your landlord at that point. Because if it's an emergency, then yeah, absolutely. So for that idea, emergencies are repairs that are urgent or necessary for health and safety of the tenant of the property, or involve the repair of a major leak or sewer pipe or roof or heating system. And back to that question, Francis, about heat, the AC unit. Now, I want to make excuses, but I think during the heat dome, it was bad in Vancouver, it was bad here, it was bad everywhere. Getting an HVAC specialist in to fix an AC unit during the heat dome would have been next to impossible. I see my internet connection is unstable, so I don't know, Ginger, if you guys are having issues. If someone wants to make sure I know if I'm...
Hello, hi Kelly. Yeah.
Okay.
It's fine,
yeah.
But at times you can hear a little bit of kind of blur in there, but it's
okay.
It's okay. Yeah.
Okay. Okay. If it gets bad, just flag me. So if the law is going to change, I don't know. To be honest, especially in Vancouver, there's been a lot of talk about how buildings have been built to capitalize on view. Floor to ceiling glass is not ideal in a heat wave like that. Providing air conditioning, in Vancouver, it's so rare for that kind of a thing to happen. And even here in Kamloops, we get hot all the time, but in the summer, but that was exceptionally hot. And so I don't know if it's going to be required to retrofit apartment buildings with heat pumps or air conditioning units or central air. I don't know. I haven't heard anything down the pipe other than, these were extreme conditions. And so I think there's going to be a lot of reviews by municipalities and the government provincially on what we generally could have done better to help people. So, air conditioning would have been nice. The short answer is I'm not sure. It does raise a question of health and safety, 100%. But again, this was a very rare occurrence. And so it's tricky to say exactly what's going to happen there. But I suspect we're going to be getting some reviews and some potential recommendations to landlords to help with that in the future. Yeah, especially for low income housing where that's not usually a consideration at all. Okay, so Helen, let's get back to your question. In a independent living mandatory meal program. Yeah. Yeah, I mean, that's kind of an interesting one. It's independent living housing with for seniors. It's kind of a quasi. It is potentially Residential Tenancy Act, but it really also is a matter of if this service is being provided and it's not being enforced. Depending on the scenario of the independent living situation, there might be a couple of recourses to go through. And so, Helen, I would rather do a little bit of research on that than give you an off-the-cuff answer. So I can follow up with Baljinder to provide an answer and maybe throw that into the slides so that everybody could benefit from that, if that's okay, Helen. I'm going to assume yes. So I'll do a little bit of response to that within the slides. Oh yeah, bedbugs or cockroaches. You know, if it induces somebody to enter into a lease agreement, I think that that's a very interesting question, Dawn. I think that yeah, I think you could ask. I think that if the landlord says yes, I think you could do some things to check and see if, especially bedbugs, to see if there is, before you enter into a lease agreement. If I were in that client's situation, I would want to double check. Now, if they move in and find out that that's not the case and that they've been lied to, the recourse would be, you know, do you want to find a new place? And if so, then we have to get you out of that lease agreement in a valid way so that the client's not dinged for getting out of the lease early. So if it's a 1-year term and you're leaving a month in, the landlord's going to try and seek some kind of compensation for that. And the defense in theory would be that, well, I've been induced into this. I specifically asked. So that's where you kind of want to have that in writing conversation almost, because you want to pin the landlord down a little bit, you know, to saying no or yes in this scenario. Yeah. It's hard because, again, a lot of times that when you get to the RTB is who is more credible or who is more believable to the arbitrator. And I mean, that's in most cases, whether it's in the RTB or small claims or superior court. But the reality is that the person who has some kind of backup to say, I asked and they said no, and this was really important to me and I made clear and they lied. And this is how I know they lied. If you've got the email chain and then somebody who's coming along to say, yeah, actually, or there's, you know, you had to call in an infestation or a exterminator, you know, that's going to be a problem, right? So if you can get them to pin it down in email or text or, you know, however, then that's a better way to say, I need to get out of this lease agreement early. And I shouldn't have to be, if anything, I should be compensated potentially, you know, for that. But you might have a little bit harder time getting compensation for that. Maybe your moving costs. Yes, more and more people with pets. Yeah. That's a tricky one. You know what? There's been a lot of advocacy in that regard for letting pets just be a common thing without a pet deposit, or just generally saying pets should be allowed and you shouldn't restrict based on that. There has been advocacy, and I think that you might see a lot of people who have pets that didn't realize what kind of trouble they can get into. And, you know, I mean, yeah, from both perspectives, I think you can see why sometimes, it's that one bad apple spoils the bunch kind of mentality with landlords, I think, when it comes to pets. And it's usually not the case. And so there has been a lot of advocacy on that. And I know a couple of lawyers in the Lower Mainland that have been working on that for years. But it's kind of a catch-22 because it is the landlord's private property, so they should be allowed to do with it as they please or make rules within certain confines to keep the condition of their property. But I agree. I think that pets should be allowed, and they have that value. So I'm hopeful that this current government has been very open to really addressing the issues at the RTB and within the Residential Tenancy Act, and I'm hopeful that pets would fall into that one. Okay. Unilaterally imposing fees, new fees. So 12-year tenant with free parking suddenly told he has to pay $100 to park in the driveway. So if there's no tenancy agreement, there's standard terms that will apply from the Residential Tenancy Act. I believe it's section 12 that says you should have a tenancy agreement, but if not, there are standard terms that will apply. And so unilaterally imposing new fees, usually there has to be some form of an amendment or agreement in place. So it would really depend on the scenario and what the tenant has done. So if he's having to pay $100 to park all of a sudden, I think that depending on the scenario, for the new agent, if he's given enough notice, if the tenant wants to dispute that, there's a couple of ways that they can go about it. So I can add a little bit of information on services, because that's really what it is it's an amenity. So if the agreement has always been this, and now the tenant disputes that, they can try and do so, but it's going to be a little bit dependent. So if he's already started paying it, then he might be considered to have agreed to it. Otherwise, he can file an application for dispute resolution saying this is never required. And so all of a sudden, that being said, sometimes landlords are permitted. If 12 years he's not had to pay for parking, it might seem reasonable in a certain case. So it really will depend on the facts of the whole tenancy, and so it would really depend. They can't unilaterally impose the new fees necessarily. There has to be an agreement, there should be some kind of agreement between the tenant and the landlord. Okay, landlord entry. So that sun that keeps wanting to pop in. Sorry, I just want to finish just really quickly on emergency repairs. So tenants can do emergency repairs if they've attempted twice to contact the emergency repair contact and there's no response and a reasonable amount of time has passed. So depending on the emergency, you waited an hour, half an hour, depending on what's going on, you might find yourself a reasonable amount of time has passed. Now, once you've commenced it, if the landlord then gets back to you, they can step in and take over completion of the repair and then reimburse the tenant for costs. Okay, so landlord entry. So landlords can only enter your unit in the following circumstances. So this is under section 29. If the tenant gives permission at time of entry. So if the landlord knocks on the door and says, hey, I just wanted to come in, you had mentioned that the fire alarm was beeping. It's one of those wired ones and you wanted me to take a look at it and I happen to be in the area. Is it okay if I come in? If you're the tenant, you could say no, or you could say come back another day, or if the landlord gives you a call or sends you an email saying, hey, I'm going to be in the area next week. Is it okay if I pop by? And you say, yes, that's no problem. So the only catch with that scenario is that it can't be more than 30 days before. So he can't, or she can't, or they can't call you on, say, September 1 and say, hey, I'm going to be in the area October 15th. Is it okay if I come in? That's too far out. If the landlord provides housekeeping or related services, and that's agreed upon in the tenancy agreement, then they can come in. if the tenant abandoned the rental unit, so if they've just disappeared, then at a certain point, the landlord can't enter the unit, or if there's an emergency and entry is necessary to protect a life or property, so fire, something like that. That's when they can enter. They can also enter your unit if they give you written notice for at least 24 hours before, but not more than 30 days. So again, they can't give you a notice on September 1 that they're going to come in on October 15th. But they also can't say, hey, it's July 15th. I'm going to be in there this evening at 6. That's just not okay. And the written notice that they provide you has to give the purpose of the entry and the date and time. They can do a monthly inspection of your unit if they follow the process above. So as long as they give you at least 24 hours notice, they can do a monthly inspection. And they can't just give you one notice and say, I'm going to do it every month. They have to, then do a notice each month that they want to do it. And then the landlord can enter if they have a court order to do so. So that's where they get that order for possession, or potentially it's an order from the RTB that says, yeah, they can come in and inspect the unit and they're going to do it on this date. So that's landlord entry. Now with the son, just kind of thinking about that one, if he's entering as an agent, which it doesn't sound like the landlord thinks he's entering at all, then I think that that there is definitely a breach of quiet enjoyment. The landlord saying he's not coming in, but you have proof. I think you can do an application for dispute resolution and have the RTA tell the landlord you have to follow the rules. Okay, so briefly-ish, new legislative changes in COVID-19. So the most important one that's arisen and that I do want to spend a little bit of time on in the last year is the change to evictions related to renovations. So before it would be that the landlord would serve a 4-month notice to end tenancy. And at that time, they were supposed to have all permits and work orders, things necessary to demonstrate that, yes, in fact, I am doing these repairs. And then the obligation then arose to the burden was put on the tenant if they wanted to dispute that, to say, I don't think they actually are. And then you would go to a hearing, but the tenant would already be under an eviction notice. So what a rent eviction under 49 sub 6 is a permissible reason would be if you're demolishing the rental unit, if you're converting it to strata lots under a strata property act, convert the residential property into not-for-profit housing, convert it into a cooperative under the Cooperative Association Act, convert it into a unit for use by a caretaker, manager, or superintendent of the property. So if your unit in particular is now going to be converted into the one in which the property manager or the caretaker for the complex is living in, or convert the rental unit for non-residential use. So those are really like the main reasons where we have the reason for that. So if you're looking into a bit more of it, there's a little bit more changes, right? And so if you're going to be doing a rent eviction, as of July 1, the landlord has to first apply to an arbitrator with the Residential Tenancy Branch that they require an order to end the tenancy and then an order for possession for the unit as a result of one of the reasons outlined in 49.6. So what do they need to have? So this is all now, the burden is now entirely on the landlord to prove first to the RTB that they need this order for ending the tenancy early, and then to get possession. So they've got all the necessary permits and approvals required, and that they do intend in good faith to renovate or repair the unit, that the renovations or repairs require that the unit to be vacant, that the renovations or repairs are necessary to prolong or sustain the use of the rental unit or the building in which it's located. And the only reasonable way to achieve the necessary vacancy is to end the tenancy agreement. And so really what that says to me in particular, when you're looking at the Residential Tenancy Act, is that realistically, the burden then says you have to hit all of these things, not just one or two. You have to really demonstrate that the tenant has to be out of that space. Otherwise, we're going to be having to deal with a situation in which the landlord's not going to get that order, which is kind of good, and especially I think for people in the Lower Mainland, where we were seeing quite a bit of these rent evictions, largely so that landlords could increase the rent, and that was quite a bit of the bit of it. So what the Residential Tenancy Act is now saying is that we're really wanting to make sure that what you're doing is for the stated purpose before we're going to let you get somebody out. So that is a large part of the rent eviction bit. So what that means is that also is that it's still not going to be 4 months. So if the landlord says, "Here's all my permits, I've ticked that box," the reason is because I'm going to basically take it down to the studs, or it's going to make it uninhabitable or unsafe for the tenant to stay there. There's no other reasonable alternate resolutions for what we're doing, and you know that there's this good faith requirement, which is an interesting one because oftentimes it's just usually your word against theirs, and we just want to make sure that the landlord's now acting honestly and they actually are going to do what they say they're going to do. So the vacancy requirement is an interesting one. We've made this argument before in which would it have actually made it unsafe for the tenants to live in the unit? We said no. Landlord said yes. And the landlord, for whatever reason, was the one that was believed. I still don't agree with that decision, but that's just my opinion. The other part is whether or not that there's going to be a prolonged loss of service. So what does that even mean? Well, you know, if you're going to be losing electrical service, it's got to be severed for several weeks, right? Like we're not talking 2 or 3 days. I mean, alternate arrangements could be made. You know, if it has to be off for several weeks, then that's a little bit different, right? Then somebody cannot live in a unit without electricity for 3 weeks. But if it's something intermittent or a temporary loss, then that's not going to meet that standard. And so just because it would be easier or faster or more cost effective to get that unit empty so that you can do the repairs, that's not the question. The question is whether the nature and extent of the renovation or repair actually requires the unit to be vacant. And so that's what they're looking for. So cosmetic renovations, light fixture replacement, receptacles, baseboard heaters, things like that, that's not going to quite meet the standard. Realistically, it's not going to hit that bit. Some of the things that are necessary, like when they say that it's necessary to prolong or sustain the use of the unit or building, seismic upgrades, that makes sense. Electric code repairs to meet the current electrical wiring code, that makes sense. Installing sprinkler systems to the entire building for fire safety, that makes sense. So that's an example of a necessary renovation. Again, painting walls, replacing doors, that's not really going to be enough to hit that high threshold. So if we're looking at if ending the tenancy is the only reasonable way to achieve this, then that is on the landlord to provide that the work plan requires the tenancy to end. And so that's looked at objectively. And so that's, we're going to look at if the vacancy required is for an extended period of time, then we're looking at is the tenant's willingness to move out and return to the unit later is not sufficient objectively, whether vacancy is required. So that's not really going to matter so much. Like if you say, oh, the tenant will go but they want to come back when it's done. That doesn't quite hit anything as far as to benefit your tenant. If it's very, very brief period, then maybe that would work. So if it's less than 45 days and the tenant could make alternate living arrangements, then the tenancy shouldn't end, because it's not really necessary to achieve that vacancy period for the less than 45 days. So if the repairs are only slotted to maybe take 2 weeks, the tenant might be able to go and live somewhere else for 2 weeks and then come back. And that doesn't mean that the tenancy should happen because of those 2 weeks, right? So there's going to be a few different scenarios to look at, right? But from my perspective, the best part is now that the burden is on the landlord to prove these things. It's interesting because I think before these changes came into effect on July 1, I think there was a lot of latitude given, in my experience, on these types of cases to landlords making repairs, and an unnecessary burden placed on tenants to say, well, I don't think they actually did this. But they've not been in the home, so it's kind of hard to establish. It's a harder case to make under this. I think for the landlord now, they have to do the legwork ahead of time, because if they want to pursue that eviction, so that they can do repairs, they have to have all the legwork done ahead of time. Like, they have to prove that they've actually taken the time to line up contractors, line up assessments and quotes to what type of work needs to be done, gone to City Hall or planning departments in their regional districts to say, yep, here's the permits in place. And yep, I've already had, for example, if there's a structural engineer needed because there's a foundation issue or something like that, they have to really take steps. And then they have to bring that evidence package to the RTB first before the tenant can even be served an order for eviction, rather than what it was vice versa before July 1, where it was more that they get served the eviction notice, and now it's incumbent upon the tenant to dispute that this person's not actually doing what they're supposed to be doing. So I like it, which is why I'm hopeful that maybe this new government would consider a pet rule change, or say, Francis, if part of moving forward, considering climate change and all those things, that we have a bit of a slowdown in how we design buildings, or retrofitting current units, apartment units and rental units to be ready for potential heat wave. Hopefully never again. But I suspect that this might happen again in the not so near or not so distant future. So that might be one thing that comes up out of this, is that how do we better protect tenants, especially vulnerable tenants, from that kind of stuff. A couple other legislative changes and some problems. We have not seen repayment plan issues materialize out here. So repayment plans were a result from that rent freeze. And so the unpaid affected rent would have been March 18th, 2020 to August 17th, 2020. And from that point on, after August 17th, landlords and tenants were to enter into repayment plans. So if there was unpaid rent, you would spread that out over whatever time you commenced your repayment plan. So maybe September 1, if you're really on the ball, that was to get stretched out to July of this year. And so that should have been dealt with. I think it was like July 10th or 11th was the date. But in any event, we haven't seen, and I don't know about other areas of the province, but we haven't had clients come to us with an eviction notice for unpaid rent. So at least not for unpaid affected rent. And so that's kind of fizzled out. Rent increases were attempted before the freeze extended. We've only seen a couple of those. but it's now been extended to December 31st, 2021. And so that means you shouldn't have any tenants coming to you with a rent increase as a result before January 1. It shouldn't be coming into effect until at least January 2021, or sorry, 2022. I'm getting a year behind. What you have to be mindful of is that the landlords are not permitted to combine the 2020 and 2021 rent. You can't do 2 years together, right? So it's still going to be staying at that rent increase, and it's still required that the tenant is provided 3 months notice. So if a landlord is hoping to be increasing rent as of January 1, 2022, then they have to give 3 months notice. So October is when that notice should be provided for the landlord. See a few questions popping in. So you're saying can't give notice for more than 30 days in advance. Why is that? Sorry, Helen, can you which notice we're talking about? Okay, well, while Helen types that out, I'll answer Dawn's. Is there still a right of first refusal for the tenant? Yes, there is still a right of first refusal for the tenant for that 45 days. So that is...
Kelly, your internet is a little bit playing.
No.
Can you try turning off your video? It might become better that way.
How's that?
I think we'll try it for a little bit. We'll let you know.
Okay. Is it a little bit better?
Yes, it's sounding it's sounding good right now.
Okay. So Helen, I'm not sure what 30 days you're referencing in that point, because I did talk about a few different 30-day references. So if you want to just type in which 30 days we're talking about, then I'll hopefully be able to answer that question. Yes. So there is still a right of first refusal if a tenant is under that kind of. Sorry. Yeah. Okay. So the advance notice to come into your suite. So I think the reality is that a lot can change in 30 days, Helen. So if you're giving 30 days, more than 30 days notice that as a landlord you need to enter the suite, is the purpose still there? And I think too, for people like individuals, I mean, planning more than 30 days out for something like that is a little bit lengthy. So we want to make sure that things are staying as they are. Okay, so the right of first refusal. So if the tenancy is being ended under Section 49(2), so for the rent eviction, and the property's got 5 or more rental units, they could enter into a new tenancy agreement for the rental unit that takes effect once the renovations or repairs are complete. But they have to give the right form, and the landlord then completes their form, the 45 days notice of availability. And that way they have noticed at least 45 days before the renovations or repairs are finished. So if they don't want to exercise their right of first refusal, then they have no further rights respecting the rental unit, and they can rent it to someone else. So that policy still stands. If a landlord wants to give more notice to a tenant than 1 month for cause, I mean, the form itself is 1 month. It says it's a 1 month notice for cause. It's incumbent on the landlord to make sure that they are they're filing with the proper move out date. And this is one that can trip up people quite a bit, is that if, say, for example, your rent is due on September 1 and your landlord serves a notice to a 1 month notice to end tenancy on September 1 and says you have to move out September 30, that's actually not accurate. It's going to be corrected to October 31st because it has to be given at least 1 day before the rent is due for that clock to start ticking. Now, if a landlord, say, wanted to give you 2 or 3 months, I mean, there's nothing stopping them. They're the one that puts the move out date on the notice. So if they wanted to, say, use a 1 month notice for cause and they think they have good reason, but they're being nice and they're going to give you an extra couple months, that would be up to them to do. I've never seen it happen, to be honest. It's usually not my experience. If the landlord feels they have cause, they want them that tenant out sooner rather than later. But if you're being really nice, you could do that. Yeah. So, yeah. Oh, yeah. Those complexes. Yeah. It's yeah. Yeah, with the annual check-ins, yeah. So if you do 30 days, then, within the 30 days, I'm personally very risk averse in those regards. Like, if something says that it's due on the 9th day, I want to make sure it's out on the 8th day, right? So yeah, I would be even like, 29 days is probably the cap. You don't want to push your luck sometimes, Helen. Yeah. So co-tenants and units with multiple tenancy agreements are interesting. We are a bit of a university town, and so we do see where, as long as the landlord's not living in the unit, then it's still going to be under the RTA, even if there are different roommates, and the landlord has a roommate or a tenancy agreement with each tenant. And so it'll say which room they're renting. But what we've seen a bit of problem with, especially last summer and into the fall, was people were leaving to follow the work or not going to be continuing their tenancy agreement because they had no need to be in person for classes. And so that kind of became a bit of an issue where we had a lot of people moving and trying to get out of tenancy agreements early, or coming to us because all their roommates left and they're the only person there and they don't want to have to pay rent for the whole space. And that's what the landlord wants. So it created a bit of havoc. And I think the other part with co-tenants in particular is that if one of you leaves and the other stays, then you're responsible jointly and severally. So you as the remaining tenant are still responsible for the whole amount of rent if you are a co-tenant. So you both are signed on as the tenancy agreement. So it really is an interesting scenario that played out. Things are kind of taking a load back on that regard. But it's been an interesting one. Obviously, I've said, noise complaints, short tempers, code protocols. One thing I do want to talk a little bit also about is that we've got, for some of the other legislative changes to the tenancy law, one thing you might start to see is, and potentially this arises out of the heat wave, is capital expenditures. So if landlords have to increase rent because they've completed some necessary repairs to the rental unit or the building, they have to recover those costs through modest rent increases. But again, that has to be approved by the RTB director first. So how they defined a capital expenditure. Now, this has yet to be updated on the publicly available Residential Tenancy Act. I tried to find it on CanLII and on the government website, but all I've been able to find so far is an order in council that came into effect. So what do we call a capital expenditure that's eligible for that rent increase? So the government is defining it as sorry, let me pull this up. So one of the following reasons why the capital expenditure was necessary for installation, repair, replacement of a major system or major component in order to maintain the residential property of which the major system is in a state of repair that complies with health, safety, and housing standards required by law. I'm not sure if necessarily air conditioning quite falls in that, but it might. Depending on the situation. So the other part would be if it's installation, repair, or replacement of a system or component that's failed or malfunctioning or inoperative or close to the end of its useful life, or installation, repair, or replacement of a major system or major component that achieves energy use or greenhouse gas emissions or an improvement to the security of the residential property. The director of the Residential Tenancy Branch would not grant an application if it's if the tenant can establish that it was the repair or replacement is required because the landlord has been failing to maintain or repair it, or in which the landlord's been paid or entitled to be paid from another source. So maybe they got some kind of a grant to make the building a bit more green, right? So it's kind of an interesting thing. They can't, they basically what they're going to be doing is multiplying the sum of rent payable and the annual rent increase permitted would be like 3%. But I don't see this happening quite yet, but I expect that there will be a little bit more coming through. So capital expenditures is one to keep in mind of if the rent if that increase is going to be on top of another rental increase. So there's going to be potentially further compensation if the landlord hasn't taken steps to use the property for the stated purpose. So again, if they said that the son's going to move in, but he doesn't, then it was up to the tenant to take steps to establish that the landlord didn't do it. Now, the amendment is actually going to make the landlord be the one to prove. So a lot of it is now shifting. A lot of the changes that are coming up is shifting the evidentiary burden back onto the landlord. So if they're saying that they're using it because family members moving in, they have to prove that they are actually doing it. So that again also takes effect on the 1st of July. Now, this might be a little bit more fun for me, but they were also expanding the review grounds and administrative penalties. So if is required of a decision, they're going to be changing how the RTB can actually review the decision. Now, the hope, I think, from the government is that this is going to prevent more cases from having to go to court and tying up the court system, which reduces costs. Judicial reviews are usually not cheap. We don't do too many of them. But I mean, this will be, let's see how it goes, because usually the review process internally with the RTB is usually they just affirm their own decisions, and it's very rare that it actually gets overturned within their own internal system. And the scope of allowing is very limited. You have to basically establish that the arbitrator got something super wrong, or there's a new piece of evidence that was not in anybody's possession until after the decision was made, or you can prove that the other party committed fraud, and it's got to be a pretty high threshold. So I we'll see. Administrative penalties will be interesting to see how they actually go. Now it's going to be the RTB has authority to undertake a review on their own initiative rather than having to wait for the client to file for a review. So that's an interesting point. You got a couple more questions. I only got one more question. Okay. Strata management and landlords. So if it's the landlord or the strata, It's not going to be up to the tenant to mediate. Typically, strata and landlord, that's a totally separate area. Other than, the tenant saying, well, I guess I have to go to the RTV to file, to force the landlord to deal with it. But if the landlord and the strata company are in dispute, usually there's a bigger issue brewing. So sometimes the tenants are just, just keep your receipts for anything you've had to incur as a result of whatever repair is needed. But that one's hard because you really have no say in that dispute, unfortunately. And so that might entail the landlord taking the strata to court, or the strata taking the landlord to court, or their insurance policies or companies fighting about it. Okay. I think we got that. Okay, so I'll just give a little bit on our protocols and our best practices, just in how we deal with things. So they've really, over at the Residential Tenancy Branch, has really pushed online, their online platform, and most clients do use it. In March, I have this, it says this month, it came out in March, and that's usually when they update their forms, but it's always important to make sure you're using the most current form, and the best way to do that is off of the government website. They do have hyperlinks in the presentation, so I'll make sure that those stay within. Now, what we do is we bring clients in. I have briefly here because it is COVID, and so we'll have worked on the statutory declaration, and so it's similar to an affidavit in which we use those to really confine our clients, and I'll explain why in a minute. But when we do statutory declarations, we have all the evidence that we're hoping to rely upon, or may need to rely upon during the hearing, in one single document. And there's a couple of reasons we do that. One, like I said, it confines our client to this is the important stuff, and this is all that matters. It takes a lot of the emotion out of the debate, and out of the hearing in our perspective, because you've already put your story on paper, and this is the relevant stuff. Anything that's not relevant is not on the paper, and therefore it does not need to be brought up. And then also it makes life easier for the arbitrator. Everything's in one nice, neat package. Everything is labeled, and the arbitrator is going to have a bit of an easier time following our submissions, right? We try to go through Service BC to upload our stuff now that they're open again. And that's usually how we get them to file from the clinic's perspective, because then the client can pay the filing fee. Everything is done. And a lot of our clients aren't tech savvy. So it's just easier to go to Service BC with them with the whole package, like the hard copy package, and then have it submitted through Service BC. All hearings are still by teleconference, but we have a larger conference room that we now stay in. And like I said earlier, to serve our clients best, they have to be in the room with us during a hearing so that we can, mute the phone and say, shh, don't say that. You know what I mean? It's a lot harder for in different cities. And then staying up to date on the new guidelines greatly helps streamline your appearances in front of the RTB. And so I have the hyperlinks to two that I think are probably the most important. One is establishing jurisdiction, so that's guideline 27, and then I included the link to the new guideline with respect to the rent eviction policies. So those are probably the two most important ones. But like I've been saying, our practice points is the guidelines in particular are what arbitrators follow. They are not bound by decisions. So typically when you go to court, you can hand a case to a judge and say, this is what the judge did in this case, and so therefore you should be doing the same thing. Arbitrators don't really follow that policy, even though technically they are bound by decisions of say, when you do an appeal to Supreme Court or the Court of Appeal, they are technically bound by those decisions. But what happens in practice often is that they rely on their individual discretion and the guidelines. So if you're tailoring your submissions for a hearing, use the guidelines for that specific topic. So there's one on quiet enjoyment. There's one on subletting and assignments. You know, if you use their language and flip it back to them and say, you know, for these reasons, this is why I think quiet enjoyment has been breached, and this is why it's beyond what would be considered a reasonable disturbance as policy guideline says this, right? So it's a lot easier to get the arbitrator to follow your line of thought if you're using the way they make their decisions. It doesn't make sense to me, but that's how they do it. And again, so the statutory declaration is going to be really important because it's going to keep the client focused on the content of their evidence that's been submitted in that package. If you're referring to receipts or pictures or a conversation by text that didn't make its way into the evidence package, like the screenshot of text messages saying, the landlord wanted me to move out, you know, a day early, but I couldn't. And I told them that and they said, oh, okay. And now all of a sudden the landlord is saying, well, they didn't move out on time. And they're referring to when they asked you to move out a day early. All of a sudden you have that text message that shows the landlord tried to get you, ask you to move out a day early, but you said,
Oh, Kelly, we just lost you.
Out.
Statement
Hello?
there now.
Hi, Kelly.
Hello?
Yeah, we can
Is
hear
it better
you
now?
Yeah.
Okay, where did I fall out?
Maybe go a little bit back.
Like your explanation. Okay.
So,
we lost your explanation.
Oh, okay. So we want to keep them focused on their evidence, and that's largely because when we do a statutory declaration like that, one, it helps prevent that rogue client. As soon as the client starts opening their mouth, new things come out that you've never heard before, and you're already in front of the arbitrator, and now all of a sudden your case has gone poop. But it's also helpful because you get your evidence in, and your landlord could be sitting there saying, well, I asked them to move out on February 27th, and they didn't. And they left the place a mess. And your client has text messages that you've been able to screenshot and put in your evidence package that shows the landlord asked if you could move out on February 27th, but you said no because you don't have enough time to get all your stuff out and clean and make sure everything's ready. So you need until February 28th. And the landlord responds, oh, that sucks. Okay, I get it. And now all of a sudden you've got that verbal exchange between you and the landlord, as long as you can see like who it was to or confirming their phone number, and the content of that conversation makes sense in how you're using it. That shows to the arbitrator, okay, your client's a little bit more credible and a little bit more organized. And now you've got that support to your client saying, I am telling the truth, because it is a he say, she say oftentimes in these hearings. Having your client organized and confined to their story of what is relevant helps you maintain credibility and reliability in front of an arbitrator, which is essential to all these types of hearings. And it's not uncommon that as soon as your client starts responding to things that the landlord says during the hearing, it's not uncommon to then have to like rein your client back in and say, okay, like we didn't talk about that because it's not relevant, or you don't get up.
Hello.
Upset. It happens from time to time, but I find if you can get your submissions and your statutory declaration responding.
Hello, hi Kelly, you're cutting out. Hello.
To the relevant. So just to wrap up, because it seems like we're we're at time. I'm losing better internet. So my biggest thing is following the guidelines and tailoring your submissions to those guidelines really helps with your client staying on point and not causing any surprises, because it does happen, and surprises for you are never good in a hearing. And I think that you have a better chance of success if your evidence package and your client hits the key points in the guidelines and stays on topic. And that's really, at the end of the day, what matters. How can we help clients send documents to file through? Yeah, so yeah, Dawn, I can email you the answer, or I can just tell you is we just go to a Service BC location with we print off the package. So there's the application that we print off and our evidence package, and we walk it over to the Service BC here in Kamloops is at the courthouse, but every community has a different location, and you just basically go to them and say, I need to file this RTB application. And basically what they're doing is what you would do online. So if you're comfortable doing it with your client in your office, you could do it online. It's just how we do payment. We don't kind of facilitate fee payment here. We don't have trust accounts or anything like that. So we don't really have money moving through our office. So we find it easier just to go to the RTB or go to Service BC to file the $100 filing fee. But yeah, we just go to the Service BC. Yeah. I think that's everything. Let me double check. Yeah, that's it. So I'll go, I'm going to add in that answer for Helen with respect to the meals in independent living, because sometimes how those facilities, I'll stop sharing because then we don't, maybe allow some. So we don't have like assisted living and independent living facilities can sometimes quasi fall out of RTA depending on the scenario. So I'll do a little bit of looking on that. So I'll try and add it into the slideshow and get that answer in the next day or two to Baljinder and the slides out for everybody.
Yeah, thank you, Kelly. If you have any other questions, please feel free to ask Kelly at this point.
Or you can email Baljinder after, or me, or I'll throw my email into that too, into the slideshow too. Yeah.
Well, there is a question, Kelly. Great presentation. Thank you so much. So not a question.
Oh. You're welcome. You're welcome.
Lots of participants are sending you thank you messages in the chat. So at this point, I think there are not any more questions. So thank you so much. It was a lot of information, wealth of knowledge that you shared with them. And we can run this session again, maybe in the coming months, just to help out the participants a little bit more. And thank you so much. And thank you for being flexible with us, sharing your knowledge with us, and have a wonderful day.
Thank you, Baljinder. Thank you, everybody. Have a good week and stay safe.
Yeah, thank you. Bye-bye.
Bye.